welcome to this Landmark Chambers webinar. This is the fourth in a series of webinars on the general topic of delivering major infrastructure. Today, we're considering land compensation issues, and in particular, the issue of scheme cancellation and planning assumptions. We are delighted to see so many of you joining the session today. We hope you'll find it informative and that the presentations are of assistance to you. We'd welcome any questions that you may have during the course of the proceedings. My name is Tim Mould QC. I'll be chairing today's session, and joining me are my colleagues Heather Sargent, Nick Grant and Richard Moules, whom I'll introduce as they come to make their presentations. Just before we begin, I have a few housekeeping points for you. Firstly, your microphones are automatically muted, so you will not need to adjust your local settings. We do, as I say, welcome questions throughout the session, but please submit them via text in the Q&A section, which you'll find at the top or bottom of your screen. We'll try to answer as many questions as we can, and we'll do that at the end of the presentations. This webinar is being recorded. You'll receive a link to the presentation and the recording shortly after the event closes. If you lose your connection at any point during the webinar, then we invite you to rejoin the meeting by clicking on the original link once more. And so to business. Our first speaker is Heather Sargent. Heather is listed as one of the top 5 planning juniors in the Planning Law Survey of this year. Her recent infrastructure experience includes the Heathrow third runway litigation, advising clients including Highways England and Gatwick Airport in relation to applications for development consent orders, and acting for the acquiring authority on a compulsory purchase order for a £25 million road scheme. And so over to Heather.
Good morning, everyone. Thank you, Tim. I'm going to talk about the scheme cancellation assumption, and just to start, really, for anyone who hasn't come across it before or for whom it was so long ago that they've forgotten, let's begin by just refreshing our memories as to what the scheme cancellation assumption actually is. So it reflects the no scheme principle and the Pointe-Gourde rule that compensation can't include an increase in value that's entirely due to the scheme that underlies the compulsory acquisition. It's part of the principle that compensation should be based on the value to the owner of the land that's being acquired, rather than on the value of the land being acquired to the promoter of the scheme. And so, in short, you have to disregard both increases and decreases in value that are caused by the scheme itself. And the result of that is that value falls to be assessed by reference to the no scheme world. So by assessing the state of affairs that would have existed if there hadn't been any scheme of compulsory acquisition. Now that all sounds really straightforward, but as many of you will know, prior to 2017 at any rate, the position was very complicated. The previous version of the 1961 Act had a lacuna in it that meant that in some circumstances, the Pointe-Gourde principle still operated, even once you'd applied the provisions of the Act. So the 1961 Act was amended excuse me, by the Neighbourhood Planning Act 2017, with effect from the 22nd of September of that year, and the amended provisions now apply to CPOs that are authorised on or after that date. The Upper Tribunal has begun to consider some of the new provisions, and Richard and Nick are going to explain the recent Curzon Park decision of the Upper Tribunal, but there haven't yet been any High Court or Court of Appeal decisions, so it remains to be seen what the courts will make of the finer details of the new provisions in due course. If we turn to look then at the provisions of the 1961 Act as amended, the starting point is section 5 still, which sets out the rules for assessing compensation. So you make no allowance for the fact that the acquisition is compulsory. The value of the land is taken to be the amount that it would obtain if it was sold in the open market by a willing seller. The relevant valuation date, by the way, is defined in section 5A. It's quite a lengthy definition, so I haven't set it out here. And then the new provision that we're concerned with this morning really is 2A at the bottom there in bold. So the value of land referred to in Rule 2 is to be assessed in the light of the no scheme principle set out in section 6A. So turning to section 6A, we find section 6A1 explains that the no scheme principle is to be applied, and then section 6A2 defines the no scheme principle. So it explicitly now states that any increase in the value of land caused by the scheme or the prospect of the scheme is to be disregarded, and equally the same for any decrease in the value of land. Now, just on this subsection 2A, previously the no scheme principles in section 6 and schedule 1 to the Act made no provision in respect of value that was attributable to development of the acquired land, so the subject land itself, whereas the Pointe-Gourde principle required enhanced value from both the proposed use of the subject land and the proposed use of other land within the scheme to be disregarded. That's the Waters case. Section 6A now appears to deal with both the land being acquired and with other land. It simply requires increases or decreases in the value of land to be disregarded. So that appears to encompass increases or decreases in the value of the subject land or in the value of other land within the scheme. And equally, previously section 6 didn't require enhancement attributable to the development of land that had been purchased by agreement, again as part of the scheme, to be disregarded, whereas now section 6A appears to deal also with land that has been acquired by agreement as part of the scheme. So you disregard increases and decreases in value that result from the scheme, including any land that's been acquired voluntarily. Turning then slightly too quickly to the no scheme rules, you'll see that section 6A3 explains that in applying the no scheme principle, the no scheme rules are to be observed, and then they're set out in subsections 4 to 8. So first of all, assume that the scheme was cancelled on the relevant valuation date. Secondly, assume that no action has been taken wholly or mainly for the purposes of the scheme. Then the third rule requires you to assume that there's no prospect of the same scheme or any project to meet the same or substantially the same need being carried out in the exercise of a statutory function or by the exercise of compulsory purchase powers. And then Rule 4 requires it to be assumed that no other projects would be carried out in the exercise of a statutory function or by the exercise of compulsory purchase powers if the scheme had been cancelled on the relevant valuation date. So again, simply just assuming that the scheme sort of got off the ground but then was cancelled on the relevant valuation date. Rule 5, if there was a reduction in the value of land as a result of the prospect of the scheme or the fact that the land was blighted as a result of the scheme, then that has to be disregarded as well. And then the next subsection that I want to mention briefly is section 6A subsection 10, which simply says, see also section 14 for assumptions to be made in respect of planning permission. So what that means is that once the no scheme world has been established, the planning assumptions in section 14 of the 1961 Act are engaged to determine what, if any, planning permissions would be available for that land in the circumstances of the no scheme world. And the relevant provision in section 14 is section 14 subsection 5, and you'll hear much more about the planning assumptions from the other speakers shortly. Then what the amendments to the Act have also done is to explain what the scheme actually encompasses, or at least more of an attempt has been made than there was previously in the legislation. So Section 6D1 explains that the scheme means the scheme of development underlying the acquisition. That is then subject to 60 subsections 2 to 5. So subsection 2 deals with urban development areas, with new towns and with mayoral development areas. And subsection 3 is quite significant. So it provides that where land is acquired for regeneration or redevelopment that's facilitated or made possible by a relevant transport project, then the scheme includes the relevant transport project. So what that means is that you ignore increases or decreases in value that result from the relevant transport project as well, when you're valuing the land for the purposes of compensation. And there's then a detailed definition of what exactly is or is not a relevant transport project. Sorry, I don't know why my mouse is not playing ball this morning. So then subsection 5 deals with what happens where there's a dispute as to the identity of the underlying scheme. It's for the upper tribunal to identify the underlying scheme as a question of fact. But there is now express provision that the underlying scheme is taken to be the scheme provided for by the act or other instrument that authorises the compulsory acquisition, unless either party can show that the underlying scheme is larger than, but incorporates the scheme that's provided for by the instrument in question. But you can only be permitted to advance evidence of a larger scheme if the larger scheme is identified in the instrument authorising the compulsory the compulsory acquisition and any documents available with it. So something to bear in mind when you're putting together obviously your CPO documentation is, have you been sufficiently clear, and will you be able in due course successfully to argue, you know, for what you want the scheme to be. Make sure that you've got your documentation in order, and that if you need to, you can in due course successfully rely on these provisions in subsection 5. So make sure your documentation is clear and that it will fall within the scope of this section. The final couple of questions that I just wanted to think about briefly in relation to the scheme cancellation assumption. First of all, can special purchases be taken into account in assessing compensation? So for example, if you've got an adjoining landowner who has a particular interest in the subject land, can their position be taken into account? The answer to that is yes. If there are special purchases in the no scheme world, importantly, then they can be accounted for in the valuation. And equally again, if in the no scheme world there is marriage or ransom value on the facts, then that is something again that can be factored into the valuation of the land. So that's it from me, first of all, on the scheme cancellation assumption, and I'll hand back to Tim.
Thank you very much indeed, Heather. Our next speaker is Nick Grant. Nick joined Chambers last year. He currently has a practice which spans all of Landmark's core areas of expertise, that is to say planning, property, public and environmental law. He spent a good deal of time with David Elvin QC when in pupillage, and he had a great deal of experience of compulsory purchase work whilst with David. That has continued as part of his practice, and he advises both landowners and acquiring authorities. He's regularly instructed by the Department for Transport to advise on property planning and compulsory purchase matters arising from major schemes such as rail projects, including, for example, HS2. So Nick is going to speak to us about planning assumptions.
Thanks, Tim. As Heather has explained, the point of the planning assumptions is, okay, sorry, that's the materials. The role of the planning assumptions is effectively to lay out in the no scheme world how you take account of effectively development value of the land. Rule 2 of section 5, which Heather's already touched on, says effectively you have to look at the open market value of the land, and then you get into section 14, which contains the planning assumptions, and section 14.1, as you can see on the bottom of your screen, effectively says this is about helping calculate the value of land in accordance with rule 2. Section 14, as it currently exists, has been amended fairly significantly twice recently. So there were a series of amendments in 2011 to what were then sections 14 to 18. And then there was another set of amendments in 2017 to what was then sections 14 and 15, and effectively omitting section 15. I'm only going to talk about the position from sort of 2017 onwards, so the position as it currently is. But if you're dealing with a compensation claim from one of those earlier periods, then there are going to be nuances that I'm not bringing out here. So what are the planning assumptions? Well, Richard's going to talk a lot more about the Curzon Park case, but it does include quite a helpful just overview of the planning assumptions, and effectively there are four. You take into account, in determining the value of the land, any real planning permissions that currently exist, the prospect of other planning permissions being granted on or after the valuation date, and the last two relate to appropriate alternative development. And you assume any planning permissions have been granted that there was a reasonable prospect would have been granted at the valuation date, and you also take into account planning permissions for AAD that would have been granted after the valuation date. I'm going to take all of those in a bit more detail, but that's a broad, helpful outline. So first, extant planning permissions. This is fairly simple. The rule is in 14.2a. It's up on your screens. Note that in the definition, it's planning permissions for the relevant land or other land. That is a sea change from the previous iteration of the section. Also note section 14.9 here, when we're talking about what planning permissions currently exist. It is immaterial whether they are conditional, unconditional, made on an ordinary application, an outline application, etc. It is, as they say in Curzon, simply listed from the real world. The second assumption is found in 14.2b. That's up on your screen now, and it's effectively taking account of the prospect on the assumptions set out in subsection 5, which I will come to, but otherwise in the circumstances known to the market at the time of planning permission being granted on or after the valuation date. Some key points that I want to draw out here. First, we're dealing in this rule with the prospect of planning permission, so it's not certain that they will be granted, and again, any valuation will take that into account. 14.5, as I said, I've come back to, but this is very similar to the scheme cancellation assumptions. The third comes down to, or the third and fourth assumptions are both related to appropriate alternative development. This is dealt with by sections 14.3 and 4. I'm going to start with section 14.4, which tells you what alternative appropriate development is, and then move on to subsection 3, which tells you how it's taken into account. So the full definition in 14.4 is on your screens, but there's two elements to AAD. First, it's development on the relevant land alone or relevant land together with other land, other than development for which planning permission is in force at the relevant valuation date. And just as a throwback, when it talks about planning permission in force, the same section 14.9 assumptions that it points that it doesn't matter if it's conditional, etc., apply equally here. Second, the second limit in subsection B is that on the assumptions outlined in subsection 5, but otherwise on the facts known to the market at the valuation date, planning permission could reasonably have been expected to be granted on an application either decided on valuation date or after that date. The 2 points of A, reasonable expectation, and B, on or after the date are quite important, because we then go on to subsection 14.3, which explains how you take these into account. And the overarching point is this: it elevates what could reasonably have been expected to be granted into a certainty that it will be granted. And this is done in two ways, depending on whether it's planning permission or AAD that you would expect to be granted either on the valuation date or after. If you would expect it to be granted on the valuation date, you simply assume it is in force. If it is expected to be granted after the valuation date, you assume it is certain that it will be granted at that later time. that being the later time being the time you would reasonably expect it to have been granted. So, as I said, this transforms what could be a reasonable expectation into effectively a certainty. It's not a sort of a hoop value situation. So I've mentioned the section 14.5 assumptions. They've appeared a couple of times, so the question is, what are they? Now again, I've put them up on your screen now, and the more discerning members of the audience will note they're in fact extremely similar to the scheme cancellation assumption rules that Heather has already talked about, and of course are in fact referred to in section 6A10, which Heather has flagged. So they are the scheme of development underlying the acquisition is cancelled on the launch date, that no other action has been taken by the acquiring authority, that there's no prospect of the same scheme or any other project being carried out in the exercise of the function, and finally, letter D refers to if the scheme was used for the relevant land for or in connection with the construction of a highway. There are a couple of nuances to D which I'd like to bring out. First, subsection 14.7 provides that when it's talking about construction of a highway, it includes the alteration or improvement of that highway. Secondly, the anonymised upper tribunal decision in Re 14.5D. This goes back to a point that Heather's actually already flagged in her presentation. But the question that was put in that case is, what happens if the land pre any sort of scheme had ransom value? So in that case, the CPO scheme was for a significant site adjacent to the land in issue. The owners of the land in issue said that even if that scheme did not exist, any planning permission that was going to be granted on that site would have needed an access over their land. So they, as private owners, could have constructed that highway, and therefore the ransom value should be taken into account. The other side effectively put the matter in reverse and said, no, section 14.5D prevents any assumed planning permission for a highway, and therefore any sort of development on that adjacent site just could not have come forward because it wouldn't have had access. So the question for the tribunal is which one of these interpretations was correct, and applying effectively the principle of equivalence and the idea that you shouldn't be expropriating any value without compensation. They said effectively that ransom value in this case could be taken into account. So that's quite an important point if you're a private landowner of a ransom strip. A couple of other points I want to make on this. First, the launch date is defined in section 14.6, and subject to some nuances, you're basically looking at the date of first publication. Secondly, again, if there's any dispute as to what's the underlying scheme, refer it to the upper tribunal. It's a question of fact. And again, you see some assumptions there in section 14.8, or some points in 14.8, I should say, that are very similar to those in section 6D5, which Heather has already spoken about. So finally, a couple of key points, or three, I suppose, key points that I want to draw out, looking at this as a whole. There are lots of references to valuation date. As has already been pointed out, this is outlined in section 5A. If you're dealing with a blight notice, it's a bit more complicated, but that's dealt with in Lockwood and Reeves. So just have a look at those. How do you establish the million-dollar question of whether it's reasonably likely planning permission would be granted? Well, three ways. First, you can agree it. Second, you can take it to the upper tribunal and ask them to decide on the balance of expert evidence. Third, for AADs only, you can apply for a certificate, which Richard is going to pick up on. If it can't be agreed, the question for the upper tribunal is whether it could reasonably have been expected to be granted. That's determined on the balance of probabilities. And the fundamental question is, what would a reasonable LPA have decided, having correctly directed itself on law and policy at the valuation date? This particularly comes out in Leach, where it effectively decided that the particular LPA in issue had been misinterpreting its policies, and so a number of planning permissions had been granted, which, on that mistaken assumption, it had been argued that because of the principle of consistency in public decision-making, a further planning permission would have been granted in that same vein, and the upper tribunal said, no, we have to assume that they would be getting it right, they have been getting it wrong, and we are going to say no permission would have been granted. Final key point is the effect of the permission on value. It's frequently said that planning permission itself doesn't confer value. Certainly, Lord Denning said that in Camrose. The point is there going to be demand for what's built? Can it be implemented? If so, if there's no demand, or if it can't be implemented, then the value is in fact pretty negligible, and you get that from Viscount Camrose and both Ivans and Sons. So that's a bit of a quick run through. I'm pretty sure that's it pretty much for me. So I too shall now hand back to Tim.
Thank you very much indeed, Nick, for that informative talk. Our third speaker today is Richard Moules. Richard is a specialist in planning and compulsory purchase law and practice. He's a member of the Attorney General's A Panel of Counsel. He regularly appears in the Upper Tribunal Lands Chamber and in the higher courts in compulsory purchase and valuation cases. He acted for the Mayor of London, promoting his first compulsory purchase order, a housing regeneration scheme for the Southall Gasworks site, and he acted for two of the successful landowners in the recent Curzon Park hearing of a preliminary issue in relation to the High Speed 2, the HS2 Phase 1 scheme, which was heard by the Upper Tribunal earlier this year. Richard.
Thank you very much, Tim. Good morning, everyone. In my presentation, I'm going to discuss the role of certificates of appropriate alternative development under Section 17 of the 1961 Act. To begin with, it's helpful to understand why somebody might want to apply for a CAAD in the first place. And the starting point, as we've already heard, is that market value may include the development value of land. So if land is sold in the open market, purchasers will take into account the value of existing planning permissions and also the possibility of obtaining planning permission in the future. And so to ascertain the development value of land, it's necessary for the valuer to know what development potential must be assumed when carrying out the valuation exercise. And so we've heard from Nick already that the significance of development being identified as AAD is that when compensation is assessed, it must be assumed that planning permission for that development, i.e. the AAD, was in force at the valuation date or would with certainty have been in force at some future date. That's Section 14.3 of the 1961 Act. As I said at the bottom of this slide, following the Localism Act, where there was at the valuation date a reasonable expectation of a particular planning permission being granted, ignoring the scheme and the CPO, there is a deemed assumption that planning permission is in force. So the reasonable expectation is elevated to a certainty for the purposes of valuation. Now, against that background, a CAAD is a means of determining what a site could have been used for if the scheme did not exist. It is an application made by either the claimant or the acquiring authority, in the first instance to the local planning authority, but with a right of appeal against the authority's determination to the Upper Tribunal. And Tim, in his presentation, will talk about CAAD appeals in the Tribunal. The function of a CAAD is to identify every description of development, if any, for which planning permission could reasonably have been expected to be granted, either on the valuation date or a later date, if the land had not been acquired compulsorily. And importantly, the grant of a CAAD establishes conclusively that the development described in the CAAD is AAD, that's Section 17.6a. So an applicant for a positive CAAD believes that there would have been the prospect of planning permission, whereas the applicant for a negative CAAD, which would be the acquiring authority, believes there was no prospect, or that the prospect was of a less valuable form of development. So why might a CAAD be beneficial? I think as an overall point, a CAAD is particularly beneficial where there is real uncertainty about what the attitude of the local planning authority would have been to a planning application if the scheme did not exist. I've identified 4 sort of paradigm cases of that on the slide. The first is where there is no adopted development plan covering the land to be acquired. So in that case, it may be difficult to tell even whether the actual principle of the suggested land use would be acceptable to the local planning authority. Secondly, where the land to be acquired is shown as greenbelt in the adopted development plan. Here there may be considerable scope for the exercise of planning judgment. For example, would the proposed development preserve openness? If it wouldn't, are there very special circumstances which outweigh the harm? And so settling those questions of judgment through the CAAD process may enable the valuers then to reach an agreement on value. Thirdly, it may be that everybody knows what in principle could be built, but it's the amount and mix of it that is the issue. That's particularly the case, for example, in a large housing scheme. What may matter is what are the permissible maximum building heights on this site. There may, for example, be heritage implications of tall buildings. The particular housing mix may significantly affect valuation. And so a CAAD is a way of testing what the local authority's attitude would have been to the amount or mix of development. And then finally, it may be the nitty-gritty, it may be the extent and nature of any planning obligations and conditions which is uncertain. What would be the pre-commencement conditions? Would there be, for example, a Grampian condition? As Nick explained at the end of his presentation, issues about implementation can crucially affect value. So if there's a significant Grampian condition or difficult onerous pre-commencement conditions, that would be a matter the valuers will need to know. Would there be expensive mitigation required, which again will depress values, or would there be onerous financial contributions? Those are all matters that can be tested through a CAAD application. So what's not to like? Well, there are disadvantages of the CAAD process. And first and most fundamentally, the application may be refused by the local planning authority. That would force the applicant either to negotiate with the other side on the basis of a less favourable planning position, or to appeal the unfavourable CAAD to the tribunal. Secondly, as I said, local planning authorities, particularly those who don't have many CPOs of their own or deal regularly with CAAD applications, they sometimes find it difficult to hypothesise on the terms directed by Section 17, and that can lead to CAAD decisions which don't properly apply the statutory provisions, necessitating an appeal. I think that problem will diminish because there has been, since the amendments to the 1961 Act, there has been a significant increase in the number of CAAD applications. So I predict that many authorities will now become familiar with the process, but certainly in the past, that was a practical problem. Thirdly, the CAAD application and possible onward appeal will inevitably add cost and delay to the process. So for a claimant who's looking for an early settlement, perhaps a CAAD application will be harmful to that objective. Another point relating to local authorities is that the planning issue may be a very highly technical one, where the local planning authority doesn't have the in-house expertise to resolve it. For example, a complicated noise dispute where the local authority may have an environmental health officer, but it's really a question of detailed acoustic evidence which will determine, for example, what expensive noise mitigation is required, or whether even development in that location is in principle acceptable because it's close to a noise source. In that situation, the best way to test the issue would be through cross-examination of the rival experts in the tribunal. And so there, both parties might decide to litigate the matter in front of the tribunal straight off, rather than go through the CAAD process with the inevitable appeal to have the cross-examination in the tribunal at a later stage. Two other significant points are that Section 17 doesn't deal with retained land. So if you're dealing with a case of injurious affection to retained land, a CAAD will not necessarily narrow the planning issues. And then finally, a CAAD may not even be fully determinative of the planning status of land that's been acquired, because the tribunal can still determine a hope value claim even if a CAAD has been issued. What I want to do next is talk about the recent tribunal decision in the Secretary of State for Transport against Curzon Park. This is a decision which is now going on appeal to the Court of Appeal, and I think is of huge practical importance to practitioners in this area. There's been a large increase in the number of CAAD applications since the changes made by the Localism Act, and also as a result of large infrastructure projects such as HS2. The Curzon Park decision is essentially concerned this question: to what extent is a CAAD application or decision on Site A relevant to the determination of a CAAD application on a neighbouring site, Site B? So by way of background, the facts were this. The case concerned 4 contiguous sites in Birmingham that were acquired by CPO to construct the new HS2 terminus at Curzon Street in Birmingham. There were 4 different landowners, and the land vested on 4 different dates over about 6 months. Each of the landowners submitted CAAD applications to Birmingham, and their applications were for mixed-use development, including in each case purpose-built student accommodation. The important point was that each of their applications was self-contained. In other words, it only proposed development on their landholding. It didn't propose development covering multiple landholdings. In the real world, as I've said on the slide, the local planning authority would consider the cumulative effects of the proposed development. In the real world, there's a finite need for student accommodation, and Birmingham City Council would not have approved the total quantum of accommodation proposed in the 4 CAADs taken together. What Birmingham City Council did was consider each of the CAAD applications in isolation and grant or purport to grant them. The Secretary of State argued that that was incorrect, and that the local planning authority should have considered the CAADs together, and necessarily the Secretary of State said Birmingham would have granted CAADs for a much lower quantum of student accommodation because of the limited need, and that in turn would have led to a much lower compensation bill for the acquiring authority. So the preliminary issue for the tribunal was that set out on the slide, whether and if so how, in determining an application for a CAAD, the decision maker in determining the development for which planning permission could reasonably be expected to be granted for the purposes of section 14 may take into account the development of other land where such development is proposed as AAD in other CAAD applications made or determined arising from the compulsory acquisition of land for the same underlying scheme. Now, the tribunal answered that preliminary issue in the negative and held that the decision maker may not take into account the development of other land where such development is proposed as AAD in other CAAD applications made or determined arising from the CPO of land from the same underlying scheme. The tribunal agreed with the landowner's argument that CAAD applications were not material planning considerations for real-world planning applications, and so there was no basis in the statutory scheme for treating CAAD applications as notional or deemed planning applications, as the Secretary of State had argued. The tribunal also disagreed with the Secretary of State's argument that this interpretation would lead to excessive compensation for the inquiring authority to pay. And in essence, every landowner is claiming that they would have been the ones to meet the finite need for student accommodation, leading to an aggregate overcompensation on the Secretary of State's case. The tribunal dealt with this at paragraph 63 and said, the landowners' freedom to develop their land was taken away on the launch date of HS2 back in November 2013. And from that date up until the date of acquisition, any application for planning permission by the landowners would have been determined in the shadow of the scheme. And in those circumstances, it wasn't unfair for each landowner to be compensated on the basis of favourable assumptions about what might have been the development potential of the land had their hands not been tied by the HS2 scheme. In effect, nobody could tell who would have run the race in the real world, so it's fair to assume that each landowner would have won the race. The tribunal did, however, reject the landowner's additional argument that the scheme cancellation assumption by itself required CAAD applications on other sites to be disregarded. The landowners had argued that a CAAD is a scheme world application. In other words, it can only be applied for following a CPO. And the landowners argued that if you assume the scheme has been cancelled and that no action has been taken for the purposes of the scheme, it wouldn't have been possible to make a CAAD application, and so other CAAD applications must be disregarded. What the tribunal said about that was that the scheme cancellation assumption only requires one to disregard the scheme and action taken by the acquiring authority. It doesn't go as far as requiring a disregard of other occurrences, such as the making of a CAAD application by another landowner. Interestingly, the tribunal did note that the acquiring authority itself might have made the CAAD application, and so it's possible someone might contend that that was action taken by the acquiring authority wholly or mainly for the purposes of the scheme, within the meaning of section 14.5b. So an application for a CAAD by an acquiring authority arguably should be disregarded. The tribunal didn't really grapple with that. It said it was an esoteric point which didn't arise on the facts. As I've indicated, permission to the Court of Appeal has been granted by Lord Justice Lewison. That was granted last month, and the landowners have all filed respondents' notices seeking to uphold the tribunal's decision on the additional ground that the scheme cancellation assumption itself requires other CAAD applications to be disregarded. So this decision demonstrates that a CAAD can add considerable value to the land being compulsorily acquired. It enables landowners to maximise their land values beyond what would have been practicable in the real world. This is a point that landowners should be aware of to maximise their compensation, but also a point that acquiring authorities should consider early on in the CPO process when estimating their likely exposure. So thank you very much. I'm now going to hand over to Tim, who is going to give some practical tips on the appeal in CAAD matters before the tribunal. Thank you.
Thank you very much indeed, Richard. By way of introducing myself, I think I can simply say that I've been in this game for about 30 years now, and during that time I've spent a good deal of my daily life involved with compulsory purchase and land compensation matters. Amongst the cases I've been involved in are Clifton, the Welsh office, and the Ride International litigation, which may be familiar to many of you who are attending this webinar. The appeal to the upper tribunal is the appeal to the upper tribunal is governed by Section 18 of the Land Compensation Act 1961. Both the owner of the subject land and the acquiring authority have the right of appeal against a certificate of appropriate alternative development issued by a local planning authority. And there is also a right of appeal against the failure of the local planning authority to issue a certificate within the prescribed period of 2 months from the receipt of the application that was before them. The appeal is to the Upper Tribunal Lands Chamber, or the Lands Tribunal as many of us know it, And as I say, the statutory arrangements are set out in Section 18 of the 61 Act. The appeal must be lodged within a relatively short time. The appeal is made by means of a reference to the upper tribunal within a month of the date of issue or of the certificate, or in the absence of that taking place, within a month of the expiry of the prescribed period. Procedure on an appeal is governed by the Lands Chamber Rules 2010, and as many of you will know, the Tribunal has issued practice directions in consolidated form. They are the directions which were issued in late November 2010 by the then President of Tribunals, Lord Carnwath. These are formal court proceedings. It's often said that the proceedings on a CAAD appeal are broadly analogous to a planning appeal inquiry before an inspector. There are obviously some similarities, but it is important to understand the formality of proceedings on an appeal before the upper tribunal. In all but the most straightforward cases, the tribunal is likely to appoint a lawyer member and a surveyor member to hear an appeal under Section 18 of the 61 Act. The lawyer member will be an experienced lawyer, often a judge, and the surveyor member will be drawn from one of the small group of highly experienced and expert surveyor members who form that part of the tribunal's membership. The rules of evidence, for example, apply in the upper tribunal, and witnesses, whether they be planning experts or experts on heritage matters, or valuers indeed, they are people who will need to have not only the requisite expertise in their field, but also ideally have some experience of appearing in land compensation references before the tribunal, or certainly have access to those who do, so that they're able to speak to them about the experience. It is a challenging process to participate in proceedings of this kind. Statements of case are required, and they ordinarily should be dealt with in some considerable detail in order to be effective. The tribunal will usually give directions at a case management conference in relation to all but the most straightforward appeals of this kind. Witnesses of fact and expert witnesses give their evidence on oath, an obvious difference from proceedings on a planning appeal inquiry, and they're subject to cross-examination. They prepare their evidence not in the form of proofs, but rather in the form of witness statements, and in the case of experts, expert report, which and they're expected to prepare those with the same level of care and impartiality as is required in proceedings in the High Court, where experts provide evidence for the assistance of the court. In recent decisions, the tribunal has been at pains to emphasize the cardinal importance of expert witnesses that appear in proceedings before it, fulfilling their role as impartial experts for the court's assistance, rather than seeking in any way to advocate the case that those by whom they are instructed wish to advance. At the end of the proceedings, the tribunal almost always reserves its decision and issues that decision in a detailed written decision. If the result of the appeal is that the decision is the certificate issued by the authority is upheld, then there is no need for anything further than the decision itself. But if the tribunal vary or substitute a fresh certificate, then they will issue that certificate, and they will often seek the assistance of the parties as to its detailed drafting on the basis of their written decision before they circulate the varied or substituted certificate. What are the powers of the upper tribunal? Those are set out in the second subsection of section 18 of the 1961 Act. The tribunal is obliged to consider the matters to which the certificate relates as if the application had been made to the tribunal in the first instance. They must consider as they think appropriate either confirmation of the certificate, the variation of the certificate, or its cancellation and the issue of a different certificate in its place. So those are the range of outcomes that are available to the tribunal. It must therefore form its own opinion on the matters set out in section 17.1 of the Land Compensation Act, and indeed on the matters set out in section 17.5 of that Act. So they must consider whether, in their opinion, there is development that is appropriate alternative development, or alternatively, consider whether that is not the case. And in the former situation, they must ask themselves whether the development that they consider is appropriate alternative development was development that would have been likely to have received planning permission at the relevant valuation date, or they must consider whether it would have been likely to have received permission at a later date, and if so, they must indicate when that would have occurred. They must also consider whether there are any conditions to which planning permission would have been subjected, or whether there were any obligations, such as planning obligations or preconditions, that might have been applied in the event that permission had been granted. Each of those matters that were for the local planning authority to consider in the first instance, when the application for the certificate was made to them, must be considered afresh insofar as relevant by the tribunal on the appeal. So the point that I think merits emphasis is that this is in every material respect a fresh determination of the application, whether it be for a positive certificate on the part of the ordinarily on the part of the landowner, or in those cases where the acquiring authority has applied for a negative certificate, they must consider that question in all material respects as well. It follows that the parties should think about the practical value of an appeal from that perspective. So, for example, the landowner will want to consider with his or her team whether the certificate as issued materially underplays the planning potentialities of the subject land. If it does, then there may be merit in incurring the cost and expense of the appeal, particularly if it's felt that the appeal has a good prospect of success, because in that event, those costs will form part of the overall compensation claim. Equally, and conversely, the acquiring authority will want to consider whether any issued certificate is one that it considers exaggerates unreasonably the planning potentiality of the land, and therefore ought to be reviewed and redetermined by the upper tribunal. The practical reality, of course, is that it is more likely that the former state of affairs will arise. That is to say that the local planning authority, which will often be the same body as the acquiring authority, and although they will conduct themselves separately, it is often the case that in practice the issue is whether the certificate that has been issued either fails to identify development that ought to have been identified as appropriate alternative development, or fails to do justice to the true planning potential of the subject land. The nature of the appeal, this is a determination of the planning potentialities of the subject land on the assumption that the compulsory purchase scheme has been cancelled and will not be revived. Our earlier speakers have explained those arrangements in more detail. The tribunal will approach the appeal by reference to the statutory duties that govern the determination of a planning application. And so they will approach the matter in accordance with section 70, subsection 2 of the Town and Country Planning Act 1990, and following the statutory duty that is imposed on planning authorities by section 38, subsection 6 of the Planning and Compulsory Purchase Act 2004. Therefore, the tribunal will direct itself by reference to the statutory development plan, which governs the area within which the subject land is located. They will, as material considerations, take account of any emerging development plan policies that are material to the question raised by the appeal. They will attribute weight to the policies in statutory and emerging plans in the same way as a planning authority or a planning inspector would do at a planning appeal inquiry or a planning appeal proceedings. The National Planning Policy Framework will be a matter that will, in many cases, be of material weight to the tribunal's consideration of the appeal, as indeed will supplementary planning guidance documents. They will, in a case where the statutory duties under section 66 and section 72 of the Planning, Listing, Buildings and Conservation Act 1990 engaged. So, for example, the subject land and the development that is put forward as appropriate might affect the setting of a listed building, or might affect the setting or lie within a conservation area. They will apply and seek to follow the special duty that arises in those cases under the 1990 Listed Buildings and Conservation Area Act. And of course, where the subject land and the development that is being canvassed by the parties raises effects upon protected interests, such as nature conservation interests and so forth, they will take account of those matters, and they will consider any statutory provisions that affect planning decisions in relation to those matters, insofar as they are material to the appeal. So that is just a short list of what is obviously a much wider range of considerations that the upper tribunal will wish to consider as appropriate and as relevant in relation to an appeal under section 18 of the 1961 Act. I wish to emphasize that the upper tribunal is a specialist valuation tribunal, and the purpose of a certificate of a CAAD is principally to assist in the assessment of the market value of the subject land under Rule 2 of Section 5 of the Land Compensation Act, to which earlier speakers have referred. In terms of established principle, it is therefore a stage in applying or fulfilling the principle of fair compensation, the principle of equivalence in relation to the acquisition of land. And the tribunal will have that factor very much in the forefront of their mind in consideration of and determination of a Section 18 appeal. So they will begin from the principle that their task is to establish the planning potential of the subject land in its optimal light. It is not their task to seek to depreciate the value of the land, but of course it is not their task to exaggerate the value of the land. They must find the point at which the true value of the land in the world in which the scheme has been cancelled has been established, and its planning potential is a critical component in that analysis. But it is often the case that applicants exaggerate that potential understandably, because if one is seeking to maximize one's compensation, as is the natural instinct of an applicant, one will take that course. Conversely, acquiring authorities often have a tendency to diminish the true planning potential of the land for equally obvious reasons. Tactically, therefore, it is important to think about where the weaknesses of one's case lie in either respect. And sometimes it's helpful to advance what one considers to be the best case one can, but also to allow for some degree of fallback, so that if the tribunal is not entirely persuaded by the strength of one's best case, whether one be the landowner or the acquiring authority, they have some evidence upon which to base a slightly less ambitious determination that perhaps one has argued for. Otherwise, the risk is that the tribunal will do what it is certainly entitled and willing to do, which is to form its own judgment, and often that is a judgment which the parties find equally to be not entirely what they would have wished. So think about not only the best case, but also the fallback case that one might put forward in order to provide, if you will, some sort of insurance as to the overall outcome. And then my final slide, some considerations. Insofar as the date for assessment is concerned, I just draw your attention to section 22 of the 1961 Act. The procedure, as I've indicated, enables the tribunal to issue a certificate both as to present and future planning potentialities for the subject land. An important point is that the procedure enables the tribunal to consider and identify conditions and obligations that might, on the one hand, enable, or on the other hand, serve to limit the planning potentialities of the subject land. Thus, for example, the landowner may recognize that in order to release the true planning potential of the subject land at the relevant date, there may be some need to mitigate against activities going on in the cancelled scheme world on neighbouring sites, or there may be highway constraints that would need to be overcome in reality by the creation of some improved access arrangements. Section 17.5 of the, I should say, section 17.5b, 1 and 3 is the correct reference on the screen. Section 17.5 enables matters of that kind to be considered by the tribunal, and an indication of the arrangements that might be made by way of condition or planning obligations to be included in the certificate. Conversely, the acquiring authority may be aware of matters that would need to be controlled by condition in order to protect neighbouring interests, other stakeholder interests, in the event that planning permission were granted for the development of the subject land in the cancelled scheme world. And those are matters that the acquiring authority should therefore address in appropriate detail in its case and in its evidence to the tribunal. The focus, finally, should be on those planning considerations that add to or limit the market value of the subject land at the valuation date. Obviously, the first more from the perspective of the landowner, the second from the perspective of the acquiring authority. And the value of proceeding with an appeal under Section 18 must be judged on that basis. It is a costly and a complex process, and it is important that in advising the parties that one has well in mind the degree to which one expects to achieve a material improvement on the position as it is reflected in the certificate that has been issued by the local planning authority under Section 17. It is only in those cases where the appeal is thought likely to secure a material improvement in the position, whether it be from the landowner's perspective identifying a materially greater planning potential, or in the perspective of the acquiring authority diminishing that planning potential, and that is justified in terms of value and that it justifies, if you will, the costs of proceeding with the appeal process, that an appeal under Section 18 really ought to be contemplated. That brings me to the end of my talk, and brings us to the end of the speaking arrangements that we have. So we are going to address one or two questions, and I'll ask the speakers to come back onto screen and to unmute themselves. Thank you. The first question, I think, is directed at Richard. And the question is, Richard, is there a trigger point in the CPO's progress before which the local planning authority can refuse to determine a certificate? For instance, does the compulsory purchase order have to have been confirmed?
Thank you, Tim. No, the answer is in section 17.1 and section 22.2. The opening words of section 17.1 allow a CAAD application to be made, open quote, when an interest in land is proposed to be acquired, and it's section 22.2 that tells us when that is. And there are three circumstances in which the statute tells us an interest is being proposed to be acquired. The first is when a notice has been published or served that's required by statute, and typically that's the notice confirming the making of the CPO, not the confirmation, but the making. The second situation is where a notice has been given by a landowner requiring land to be acquired, and there's a deemed notice to treat. So that would be, for example, either a purchase notice or a blight notice under Part 6 of the Town and Country Planning Act 1990. And then thirdly, where an offer has been made in writing to negotiate for the purchase. And of course, that could occur even before the making of the CPO. So providing you fall within one of the three situations in section 22, the application is properly made and the LPA must determine it.
Thank you very much indeed, Richard. The next question is for Heather. Heather, you mentioned the reference to relevant transport projects in section 6, capital D, of the changes in relation to the scheme principle. Could you just enlighten us a little on the reasoning behind that, the insertion of that provision in the Act?
Yeah, I mean, the documentation produced alongside the Neighbourhood Planning Bill, as it then was, makes clear that the government's thinking was that new transport projects often, of course, raise land values around transport nodes or transport hubs, but those transport projects are paid for by the public purse. So the government's view was that the landowner gets what the government saw as an unearned windfall from the uplift in value caused by the project that the public has already paid for, and so the public purse shouldn't have to pay a second time. So that's the reason for insisting that the transport project goes into the scheme, into the definition of the scheme, and then has to be disregarded for the valuation.
Thank you very much, Heather. Nick, question for you. You mentioned that section 15, I think, of the Land Compensation Act, and that it remains relevant for CPOs that were confirmed before the 22nd of September 2017, I think. Could you just expand a little on that and other relevant factors?
Yeah, of course. So section 15 for those in its most recent active form, so before remission, is as you said, Tim, relevant for CPOs confirmed between sort of April 2012 and before September 2017. It relates to planning permission to be assumed for an acquiring authority's proposals. So if a relevant interest is to be acquired for purposes which involve the carrying out of the proposals of the acquiring authority for the development of the relevant land, and the planning permission for that development is not in force at the valuation date, then for the purposes of the planning assumptions, then you assume that the planning permission is in force at the relevant valuation date for the development of the relevant land or that part of it. You can't take into account, or that there's a specific exclusion for planning permissions that have been granted, but so as not to inure for the benefit of land. So, as I'm sure most people on this call know, when you grant a planning permission, section 75 of the TCPA effectively says that it inures for the benefit of the land and subsequent owners. If there's a condition restricting that to local authorities only, then there's the statutory carve-out for that. A useful case on how this works, I haven't put it on the slide, but it's called Colnaway, C-O-L-N-E-W-A-Y Limited versus the Environment Agency. It's a 2004 case. So I'll start there if you're having to deal with one of these.
All right, thank you. Well, there are a couple of other questions that I'll deal with before we close. The first is a question about cases where a certificate of appropriate alternative development has been determined without seeing the landowner's title, and then it transpires that there was a defect in that title, which might affect the ability to develop the land in the council scheme world with the benefit of the assumed planning permission. It seems to me that in those circumstances, that wouldn't affect the validity of the certificate. The certificate is judged by reference to the planning potentiality of the land rather than any consideration of title in the way that one would expect for an ordinary planning application. But of course, it may well affect the value that the assumed planning permission gives to the land interest in question. So when the tribunal comes to the valuation stage and is asked to say whether or not the existence of the assumed planning permission adds significant value to the open market value of the land for the purposes of Rule 2, if it's shown and it's established in evidence that actually for some reason of title the land could not have accommodated the development which was subject to planning permission, then obviously the market would take account of that fact and may well attribute a diminished value to the existence of the planning permission as a result. So I think that's the response to that point. And then the final question is an interesting question, which is, what is the moral justification for the public purse to recognise hope value, as Nick explained in relation to section 14. I'm not sure whether it's easy to discern the morality or otherwise of the situation, but certainly the underlying principle is that the principle of equivalence, and the principle of equivalence guarantees and has always guaranteed to the landowner, certainly since the Scott Committee modernized the arrangements for land compensation in 1919 and introduced effectively through Parliament's good offices the current arrangements for land compensation in the rules that we find in section 5 of the Land Compensation Act. The principle has been that that the landowner should receive a value for his or her land that reflects its true potential, both in terms of its existing use value, but also its value for development. And hope value, in cases where it can be established that hope value exists, hope value is an important and integral intrinsic component of the land's potentiality, of the opportunities that it presents as an asset. And it would be wrong if the landowner were deprived of that component of value where it exists simply by virtue of being unable to realize it. It may be that the question has in mind that the landowner may be deprived of the opportunity to realize the hope value, but is also absolved from the risk of that. But that isn't that conceptual issue isn't a difficulty for the Lands Tribunal, because the Lands Tribunal is well able, through the expertise that it has as a specialist valuation tribunal, to attribute both potential and risk in appropriate measure, and to grade the degree to which the land is entitled to the benefit of hope value by reference to the uncertainties and the risks that would exist at the valuation date in realizing that value. And you will often find that the tribunal takes a relatively cautious approach to the attribution of hope value, and certainly a cautious approach to the degree to which that ought to be to lead to an increase in the value of the land over its existing use value, because it recognizes that the landowner is not only deprived of the opportunity to realize the value of their land on development, but also absolved from the risk that prospect carries with it. If that is in some sense a moral explanation, then that is the explanation that one can give. But certainly, if Parliament, for example, were to legislate to exclude hope value from consideration, my own view is that that would cause a great deal of resentment amongst those whose land is affected by compulsory acquisition, and it would certainly increase that resentment very considerably over the resentment that already exists, understandably, where people are subject to expropriation for the public good. Well, that I think concludes this webinar. We very much hope that you found it useful and informative, and I shall close the proceedings and say thank you very much indeed for attending.